Hello everyone, my name is Priya and I welcome you all back to my channel. This video is going to be the last video of part 3. After this, we will start part 4 of the Indian Constitution. In the last video, we talked about Article 34, that is martial law and fundamental rights. Now in this video, we will be discussing about the last article of part 3, that is Article 35. Article 35 talks about Parliament's power to make laws for giving effect to the rights conferred by Part 3 of the Indian Constitution. Let's see what Article 35 says. This is the actual text of Article 35 according to Indian Constitution. It contains 2 clauses and the first clause contains 2 subclauses. Let's read and understand the first clause first. It says that legislation to give effect to the provisions of this part, notwithstanding anything in this constitution, Parliament shall have and the legislature of a state shall not have the power to make laws. This is the first clause of Article 35, which means, in spite of anything in this constitution, to give effect to the provisions of Part 3, Parliament will have the power and the state legislature or state government will not have the power to make laws. Subclause 1 says, with respect to any of the matters which under Clause 3 of Article 16, Clause 3 of Article 32, Article 33 and Article 34 may be provided for by law made by Parliament. So, according to subclause 1, only Parliament will have the power to make laws for Clause 3 of Article 16, Clause 3 of Article 32, Article 33 and Article 34. So, what is mentioned in these articles that only Parliament can make laws for these articles and not the state legislature? Let's see. Article 16 basically talks about right of equal opportunity in the matters of public employment. In its second clause, it is said that there will not be any discrimination on the grounds only of religion, race, caste, sex, descent, place of birth, residence or any of them while giving public employment. But in the third clause of Article 16, one exception is given, where Parliament has power to make laws for the citizens based on their residence in public employment. Now, what is this? In the second clause of Article 16, it has been said that there will not be any discrimination on the basis of residence while giving employment. And now the third clause is giving power to the Parliament to make laws in the public employment based on the residence. See, this has been done for the growth, development and upliftment of a particular state or area. Now you think yourself that if the power to make such laws is given to the state government, then the state will start making laws in their own ways and in the favor of their own people. That's why this power has been given only to the Parliament and not to the state legislature, so that there shall not be any discrimination. Coming to the next clause, that is Clause 3 of Article 32. Article 32 basically talks about remedies for enforcement of rights given by Part 3 of Indian Constitution. In its first 2 clauses, it has been said that a person can move to the Supreme Court for the enforcement of his fundamental right, and the Supreme Court has power to issue writ against the state for the violation of fundamental right. Apart from Supreme Court, High Court can also issue a writ against any state. Now, according to the third clause of Article 32, Parliament can empower any other court also to issue writ, like district court or any other subordinate court. This means Apart from Supreme Court and High Court, other courts can also get the power to issue writ, and this can only be done by the Parliament and not the state legislature. Even if any district court comes within any particular state, only Parliament can empower any other court to issue writ. Moving forward, the third article which is mentioned here is Article 33. Article 33 talks about armed forces and their fundamental rights. It says that Parliament has power to modify or abrogate the rights given in Part 3 of the Indian Constitution for 4 categories of people: members of the armed forces, members responsible for the maintenance of public order, persons employed in any bureau, intelligence or counter-intelligence organizations, and persons employed in telecommunication system for the first 3 categories. So fundamental rights of these people can be modified or abrogated. And to implement this, only Parliament has power to make laws and not the state legislature. Moving forward, the last article mentioned here is Article 34. Article 34 talks about martial law and how it affects the fundamental rights. It says Parliament has power to impose martial law in any part of the country. And during martial law, if any person takes any action or does any work which is legally incorrect to maintain law and order in the area where martial law is imposed, then the Parliament can indemnify that person for his actions. Indemnify means to compensate or to protect someone against legal liability for his actions. So basically, Parliament has power to indemnify any person and make laws during such situations. And this power doesn't exist with the state legislature or state government, even if the martial law is imposed in any state or any part of it. Only Parliament can do so. So that was about the first subclause of Clause A of Article 35. Moving to the second subclause of Clause A, which says that for prescribing punishment for those acts which are declared to be offences under this part, and Parliament shall, as soon as may be after the commencement of this Constitution, make laws for prescribing punishment for the acts referred to in subclause 2. This simply means that Parliament will have the power to make laws to impose punishment for the acts that are declared to be offences under Part 3 of the Indian Constitution. Like untouchability, which is defined in Article 17, and traffic in human being and forced labor defined in Article 23. In Article 17, it has been said that untouchability cannot be practiced, but it has not been mentioned that what will happen if someone practices it. Similarly, in Article 23, it has been stated that selling or buying of human being or forcing someone to work will be considered as offences according to the law. But it has not been mentioned in the article that what punishment will be given if someone does that. So try to understand this. When the Constitution was being written, then the Constituent Assembly said that our work is to frame the Constitution in the right way. Now what acts will be passed and what punishments will be prescribed, that Parliament will decide. That's why the Constitution gave the power to the Parliament under Article 35 to pass acts and prescribe punishments. So after the commencement of the Constitution, Parliament enacted Untouchability Offences Act 1955. which was amended in 1976 to make it more strict. Later, this act was renamed as the Protection of Civil Rights Act 1955. This act was for Article 17, untouchability. For Article 23, two acts were passed by the Parliament. Suppression of Immoral Traffic in Women and Girls Act 1956 and Bonded Labour System Abolition Act 1976. Apart from these two acts, some more acts have been passed by the Parliament for other forms of forced labour. So that was about two sub-clauses of Clause A of Article 35. Now we still have one more clause in this article, that is Clause B. Let's see what it says. It says that any law in force immediately before the commencement of this Constitution in the territory of India with respect to any of the matters referred to in subclause 1 of Clause A or providing for punishment for any act referred to in subclause 2 of that clause shall, subject to the terms thereof and to any adaptations and modifications that may be made therein under Article 372, continue in force until altered or repealed or amended by Parliament. Let me explain you this in simple words. The first thing which we need to understand here is Article 372. Why is it mentioned here? According to Article 372, it is said that all those acts and laws which were enacted before the commencement of the Constitution, that is 26 January 1950, will remain same even after the commencement of the Constitution. Here you can see it is written before the commencement of the Constitution. This is what Article 372 says. And taking reference of this, it is mentioned here in Article 35 Clause B that whichever article and clauses we have discussed till now, like Article 16 Clause 3, Article 32 Clause 3, Article 33, 34, 17, 23, the laws which have been enacted to enforce all these, whether they were made before independence or after independence, will remain in force until Parliament amends or make any changes or completely abolish them. Okay? So I think we are done with this. We have completed Article 35 also, and with this we have completed Part 3 of the Indian Constitution today. So if you have any kind of confusion or any question regarding fundamental rights, then you can ask me here. Because from the next video we will be starting our discussion over Part 4 of the Indian Constitution, that is Directive Principles of State Policy. One more thing I would like to say here, that all the articles mentioned in Article 35, their detailed videos are already on my channel. I'll put the links in the description box, you can check them out. So that's all for today, and thank you so much for watching this video.